Showing on this episode of Law Weekly, another look at some key reforms the judiciary needs to undertake. We have the views of a senior advocate of Nigeria, Adeyemi Candid Johnson. Also showing on the program, highlights from the new legal year ceremony of the High Court of the Federal Capital Territory. We also have snippets from the suit filed by a legal practitioner seeking an order of court to allow Nigerians own AK-47 rifles or other firearms for their self-defense, plus a recap of the top trending legal stories in the news. Hello and welcome to the program. I'm Shola Shoyele. As courts across the country conduct ceremonies to kickstart a new legal year, many lawyers believe that it provides a good opportunity to put on the front burner issues of judicial reforms. Now, the Justice Reform Program, JRP, has been at the forefront of advocating for such reforms. They recently wrote a letter to the Chief Justice of Nigeria, Justice Olukayode Ariwoola, to suggest some urgent and critical reforms, one of which is that priority should be given to digitization of courts. Now, this is the starting point of my conversation with the convener of JRP, Senior Advocate of Nigeria, Adeyemi Candid Johnson.
The fact is that the judicial process and the justice delivery product in Nigeria is so disfigured by maladministration, lack of organization, and lack of ethical and ideological guidance that it would require a dramatic change in many aspects which would amount to a revolution. I'm not so sure whether this or any other acting Chief Justice has the will to achieve that degree of change. But the fact is that since this is a product which is being delivered for the benefit of Nigerians, ultimately it's Nigerians whose dissatisfaction with the system that will drive change. It's interesting because someone asked me about it recently. I was talking about the reforms in Kenya in 2010. You know, they had a constitutional crisis with elections over cases over elections, and they appointed a very distinguished gentleman called William Mutunga as Chief Justice of Kenya, and his job was to transform the judiciary. Now, if you notice, you may not be aware of the time when the Nigerian judiciary was regarded as the lodestar of judicial excellence in Africa and in the Commonwealth. That is obviously not the case today. But Kenya has been recently in the news, election petition, presidential, 14 days, the decision was given. I mean, these are judges who were appointed by the president who opposed the candidate who has won. The fact is that the process by which Kenyan judges are selected is rigorous, it is transparent, it is highly competitive. This Chief Justice was interviewed on live TV for her job. So you can understand, you know, people have spoken about Rwanda and Ghana and those other countries, but the fact is, the Nigerian judicial system is not today a model of high quality justice delivery. And we would do well to learn from what Kenya did. Kenya had a judiciary which was characterized by lack of integrity, loss of reputation, incompetence. In fact, what they said in one article was that why hire a lawyer when you can hire a judge?
It was that bad?
Oh yes. And this is just 12 years later. So if there's will, many things can be done. But for an incumbent Chief Justice who does not have maybe power, resources, or even the stomach for extensive reform, there are many things that can be done to improve the quality of the product. You know, you can't improve a product unless you know what its purpose is. The purpose of the justice system is to resolve disputes between people because it is inevitable in any organized society that there will be disputes. And it is inevitable that unless those disputes are managed properly in a way that is fair, transparent, and effective, then they will cause further crisis in the organization of the social and in the social fabric. So that is the purpose. So if that is the purpose, then the job of a judge is to decide disputes. The job of a judge is not to look for mindless technicalities, to deflect from the cause of justice for the purpose of some fanciful idea. It's not his job to use Latin phrases. The fancy dress isn't even important either. The important thing is that people come before you and they know that within a very short time, the dispute will be decided in a way that I can understand, that is apparently fair, and that is consistent. When you have cases, especially corruption cases now and electoral cases, where the reputation of the judiciary has been so terribly soiled, because it seems that the practitioners in that area have an extraordinary capacity to guess decisions of the courts which may be inconsistent. So if a judge decides blue 10 times, then you should be able to guess the next time will be blue. But if you can guess it is red, then as Justice Toby said recently, you must be a suspect.
So you've talked about consistency of judgment, fairness, and integrity of the process. And this brings me to one of the points that JRP made in its letter, the need for verbatim and electronic record of proceedings of courts across the country. And JRP has seemingly pushed the burden back to the parties. Why?
Well, that's not unusual. You know, judicial resources and the cost of administration is extensive, and the resources are limited. So you have to manage them, and you have to do as much as you can, that is the government, and you have to allow the parties to do the rest. In a country like America, for example, the system of depositions in civil cases means that the parties interrogate and question witnesses outside the presence of the court. So the court gives an order, pleadings have been settled, witness statements have been received. The parties will schedule between themselves within the next 7 days deposition, and you must go to the deposition. So I want to depose your client, he's in your office, I will go there, and it'll be recorded. So we can then jointly present to the court a record of testimony. These are ways of taking away the burden of administration from the courts. And why can't we both agree? In arbitration, we do it all the time. These are parties in no less contentious disputes. We do not have all the resources for all the justice we require. So we must use the resources we have for what we must do. And other areas, there's nothing wrong. Parties are asked, after the courts in Lagos were attacked and burnt, parties were asked to provide the records. So I would go to my colleague on the other side. These are the documents I have. They're all certified by the court. Let's sign off on a paper, joint paper, saying these papers. It's very simple. In the exceptional case where a lawyer is not willing because he's unreasonable or because he's unethical to reach an agreement, then you go to the judge. But in most things, in arbitration, for example, you'll be told the party should first try and agree the order that is required and tell the tribunal. Only if the parties cannot agree will the judge come before. And someone comes before the court and has refused to agree to something which he should have agreed to, the court should punish him. Because the principal function of the court is the determination of disputes. And the principal responsibility of the lawyer is to facilitate the due and proper administration of justice.
But what happens in cases where the parties and even their counsels cannot afford to do that?
That is a problem. You have to deal with, it's like an election. Someone says that if you want to make electronic voting, some areas of the country do not have internet and cannot be reached, they're reached by water. That's true. So let's do the quarter that can be done, and then use the rest of our resources for those that can't.
So the way that you've explained it, it's common sense. It's so easy that, why is it that we're not even going down this route?
You know, nobody's thinking, Willie Mutunga's plan for the Chinese judiciary was called the Judicial Transformation Plan. They studied all the reports, they studied all the suggestions, and then they appointed a chief executive for judicial reform. They appointed a high court judge to study. They consulted widely. My father, my late and dear father, there are many things that he used to say which I remember with gratitude. One of the things he used to say was contentment. In Yoruba, itelorun. The second thing he used to say very often was, common sense is not common. You say, but it's common sense. Yeah, but that man doesn't understand it. To reform a thing, you must know what is the purpose. What is the purpose of system of justice? If you tell them, and we all agree, it's to determine disputes fairly, promptly, in a transparent way that people can understand and which people can predict, then it means that when a case comes before you, you're going to very quickly throw away all these irrelevant technical points. Our judges, especially in the appellate courts, delight in irrelevant technicality. They don't understand that their job is to decide disputes. They think their job is to entertain the public with irrelevant technical points. unless a technical point is substantive, unless it affects the merit of the decision, there is no reason why it should stop a case from being heard. So, for example, you have this ridiculous question of who signed it, whether it was signed for a law firm or not. If a lawyer appears before the court cannot question his right to appear for his client. If a lawyer comes before the court and says, this document, it's my signature, but I didn't tick a box or I didn't write something, some judges who are not as busy as they should think that's an important point. The important point is that a qualified legal practitioner has signed the document. Why? For the protection of the public. It's not a technical point to be used to dance away from justice. But our judges, and the appellate courts in particular, like to dance away from the merits of a case. Because the judicial administration is not efficient, judges have too much work. So they use technicalities as a device for triaging cases. If you make a mistake, that's it, we've caught you, you're out. But then it undermines the quality of justice and the reputation of judges. And the second thing is that some of them just can't think very well. Not all of them, of course, but quite a few. Why should you have to beg the Chief Justice to improve administration of justice? I don't understand it.
So in all of the time that JRP has been writing to the CJs, giving all this advice about what to do, has the CJs, any of them ever written back to say that we would partner with you to achieve this? Good suggestion here.
No. They're probably still having congratulatory visits, which takes quite a bit of time as well.
3 months.
Well, you know. So that's the situation. You know, if I was given a job, I wouldn't be able to sleep without addressing what needs to be done. My tenure is 2 years. I need to do it. And when I'm gone, I'm gone. If I attend a job and I give it my best, when I'm done, I'm done. But some people take on a job for the glory. I neither have the interest or time for glory. I just think that it's important, if you are regarded highly enough to be trusted with important work, then you should give it your best, do your best, and as they say, leave the rest.
Let's round off with a sort of agenda setting for the NBA. We've recently sworn in new national officers for the Nigerian Bar Association, and I'm just wondering, what do you think that they can do differently, you know, with regards to achieving some of these things that we've talked about, judicial reforms? Is there anything more that could be done?
Well, what we have is a product of a collaboration with the Nigerian Bar Association. That's worthy of commendation. Again, I think that with the last administration, they've done what they can do and they've left. And I think that there is a body of work which indicates that there was some high quality product output from them, and they should be commended. Now, the next incumbent has to consider what he wants to achieve. Being NBA president is no achievement. The job of the leader of what is in fact a professional union or organization is to promote the environment in which that profession will thrive. NBA declares that it is dedicated to the rule of law, but this is not its primary function. There's so many other irrelevant things that NBA does, you know, holding parties, all these things. There's a whole lot of frivolity, but I understand that you need to entertain people, and that's fair enough. But then, in his own quiet moment, the president needs to consider whether there are 3 or 4 things he can achieve. I don't think that you can achieve much by not telling the truth. I think that there are many things that are startlingly wrong. Collapse of ethical values, collapse of professional responsibility, lack of dedication, lack of professional skill, both at the bar and at the bench. But if you take these things on, somebody will be offended and someone may try and put his fingers in your eyes. When you have become president of the Nigerian Bar Association, you should not be afraid of such things. I can tell you, some people may tell you the name of the Chief Justice of Kenya. Many Nigerians know the name of the Chief Justice of Kenya because many of them are reading the decision and they're seeing how this 62-year-old woman conducts herself. And I don't know if you remember the names of the last 3 Chief Justices of Nigeria. I hardly do. I'm a senior advocate of Nigeria. They will tell you about the Wolf reforms and the things that Lord Denning did and the Scott reforms, because these people applied the power that was given to them to improve the quality of justice dispensation. That's enough.
Welcome back. The Chief Judge of the High Court of the Federal Capital Territory, Justice Hussein Baba Yusuf, is asking judicial officers and legal practitioners to ensure they work assiduously to protect the sanctity of the rule of law ahead of the forthcoming 2023 general elections. Justice Baba Yusuf was speaking at the commencement of the 2022-2023 legal year of the High Court of the Federal Capital Territory. We have details in this report. The beautifully decorated venue of the Federal Capital Territory High Court indicates celebration for members of the court as they mark the commencement of the 2022-2023 legal year. Inside the ceremonial court is filled to its brim with justices, senior advocates of Nigeria, traditional rulers, other members of the public, and well-wishers. They are here to take stock of the progress they have made so far and the necessary improvements they hope to attain in the year ahead. Delivering his speech, the Chief Judge of the court reminds the legal practitioners that a lot is expected of the judiciary in the new year, especially because of the elections.
As we approach another general election year, it is expected that there will be heightened activities within the presence of the court. It is therefore imperative for us as law practitioners, both the bar and the bench, to brace up for the challenges ahead. The Nigerian society looks up to us to continue to provide legal services that seek to stabilize the polity.
The Nigerian Bar Association also commends the court for the speedy dispensation of justice delivery.
Mr. President is concerned that his gratitude is incidences and occasions of abuse of ex parte orders is very, very minimal or non-existent in the FCT judiciary. And he commends my Lord, the CJ, and the judges of the FCT judiciary.
The body of benches on its part calls for quick assignment of cases filed to respective judges.
There's growing trend of delay in assignment of cases when filed, as in most cases they are not brought to the attention of the Chief Judge, who in his characteristic manner will waste no time in sending such cases assigned timeously. To this end, this should be addressed so that this procedural wrangles and bottleneck of the civil service is not taking its tool or route here.
As the Federal Capital Territory High Court commences its new legal year, especially during this election period, the expectation is that the judicial officers will continue to uphold their oath of office and discharge justice without fear or favor. In other news, the current spate of insecurity in the country has prompted a suit by a Lagos-based lawyer, Malcolm Omirabo, seeking an order of court compelling President Muhammadu Buhari to allow Nigerians own AK-47 rifles or other firearms for their self-defense. The lawyer had instituted the suit at the Federal High Court Abuja since 2021, seeking, among other things, that he and other Nigerians be granted license to own firearms to defend themselves against criminal elements, including bandits and kidnappers. Justice Ahmed Mohammed has adjourned till January the 24th, 2023, to enable the plaintiffs serve all court papers in the matter on the defendants.
What is the National Assembly? What are they doing about the Firearms Act? It's an ancient law. It's a very important law. I recommend that every community should have AK-47. Every school, every street should have AK-47. Every church, every mosque should have AK, because what we're talking about, the only antidote to this unlawful violence by these state non-state actors is proportional use of force. We need balance of violence. You don't expect me now to have shakabula or pump action to defend myself against somebody who has an AK-47. It is not proportional. the law, the criminal code and penal code and the constitution has made it clear. If I kill you in the process of defending myself, I have not committed murder. So let us exploit this thing, and I'm asking the court to compel the president to give me my AK-47. And I'm also asking the court to compel the governors to apply properly for AK-47 to defend the rights and properties of Nigeria, their right to dignity of human person, liberty. If you are kidnapped, you'll be so debased and so dehumanized. Your liberty, your liberty will be taken away. Your dignity of person will be taken away. And these are the things we are saying.
Let's now bring you a recap of some other top stories we covered at the courts.
We begin with the report that the Supreme Court of Nigeria has affirmed the Speaker of the Delta State House of Assembly, Oborewori Sharif, as the governorship candidate of the People's Democratic Party in the 2023 governorship election in Delta State. The Apex Court upheld the decision of the Court of Appeal delivered on August 29th, which voided and set aside the judgment of the Federal High Court of July 7, 2022, that nullified his nomination on the ground of certificate forgery and perjury. Justice Tijani Abubakar, in a lead judgment, held that the grievous allegations of supply of false information and certificate forgery brought against the Speaker cannot be proved beyond reasonable doubt with the use of originating summons. The court also held that the case of the appellant has no merit, and it was subsequently dismissed. At the Court of Appeal sitting in Abuja, the federal government has filed an appeal against the judgment which freed the leader of the indigenous people of Biafra, Nnamdi Kanu, at the Supreme Court. It is asking the Apex Court to stay execution of the appellate court's judgment delivered on October 13th this year. The federal government faulted the decision of the Court of Appeal and asked the court to set it aside. The federal government also contends further that the appellate court erred when it struck out the pending charge against Mr. Kanu on the grounds that the trial court no longer possessed the jurisdiction to continue the trial because of the way Kanu was returned to the country after allegedly jumping bail. No date has been fixed for the hearing. Still in Abuja, Justice Inyangeku of the Federal High Court has fixed January 27, 2023 to hear a case instituted by the coalition of northern groups seeking a referendum to determine the fate of IPOB and other separatist organizations in Nigeria. The adjournment came after the court gave all interested parties time to adopt their processes. The coalition of northern groups had in June last year taken the National Assembly and the Attorney General of the Federation to court, seeking to stop the Constitution review exercise and in its place conduct a referendum to determine who remains part of Nigeria. In Lagos, the State High Court sitting in Ikeja has fixed December 6 for the trial of a former Attorney General of the state, Senior Advocate of Nigeria, Olashukwu Oshashiri. The court fixed the date after granting him bail. The only condition for bail was for his lead counsel, Senior Advocate of Nigeria, Adeyemi Candid Johnson, to write a personal undertaking to always present his clients in court throughout his trial. Mr. Shashere was arraigned before the court on a 2-count charge bordering on corrupt offers to public officers contrary to and punishable under Section 9 subsection 1 A-B of the Corrupt Practices and Other Related Offences ICPC Act 2000. Still in Lagos, a coroner's inquest into the circumstances surrounding the death of Jumoke Oyeleke, the lady reportedly killed by a stray bullet during a rally in Lagos State, has returned a verdict indicting the police. The coroner, Magistrate Mukaila Fadeyi, who sat at the magistrate court in the Ogba area of Lagos, says the police shot the deceased and caused her untimely death. On July 3rd, Yoruba Nation agitators converged at the Gani Fahimi Freedom Park in Ojota area of Lagos to demand an independent state for the southwest region. It was alleged that police shot into the air and used tear gas canisters to disperse the crowd, and Jumoke, a 25-year-old salesgirl, was shot dead. And we round off in Yobe State, where the High Court sitting in Potiskum has adjourned the suit between the state government, Lance Corporal John Gabriel, and Lance Corporal Adami Gideon to 7th and 8th November 2022 for hearing in connection to the killing of an Islamic cleric, Sheikh Goni Aisami. The presiding judge, Justice Usman Zana Mohammed, adjourned after the accused persons were arraigned on a 4-count charge. They all pleaded not guilty. Sheikh Goni Aisami was allegedly killed along Gashua Jajimaji Road in Yobe State on 19th August 2022 after he offered a ride to the dismissed Lance Corporal John Gabriel, who later shot him in the head in his quest to snatch his vehicle.
And that's the program this week. If you missed any part of it, you can find the video and past episodes on our YouTube channel. I'm Shola Shele. Thank you for watching and see you next week.